evening, and we're moving into the balance of item number 9, our committee reports, starting with Ledge and Reg, and then we'll do the Children's Vision, Consumer Protection, Public Relations, Practice and Education. Ms. Michelin, if you could brief us on Ledge and Reg.
Sure. We had our Ledge Reg committee meeting. One of the topics we discussed was the Mobile Clinic Task Force, which was a result of the August 3rd meeting that we had in hearing public comment regarding the mobile clinic issue. At this time, I'm going to look at Donna. Donna and Dr. Wong were on the mobile clinic work group. They made a presentation to the Ledge Reg committee, which you can see. It's linked to the agenda. But we asked them to go out, and I don't know if you met with the stakeholders, to reach out to stakeholders to get some feedback, and then bring it back to the full board. So I'm going to defer to Donna and have her give an update on from the task force perspective.
We did meet with the task force, and it was a very, very productive meeting. We came up with language that the majority of them were supportive of. You're going to present that today, right?
No, not the specific language.
Oh.
So what happened was that we presented language to the Ledge Reg committee, and the Ledge Reg committee had asked the committee to go back and look at issues as far as requiring physician's referral or order prior to administering the homebound services. And the thought is to have some kind of accountability to make sure that the board knows who's going out to patient homes. And it's not just going out and making a career out of going to all these different patients. And the other part of it, and Ms. Michelin had brought up, if that part of the requirement is it has concerns with stakeholders, which we received some feedback that there's concerns requiring that physician order prior to going to the patient home. Ms. Michelin proposed potentially creating a separate license, so we are still able to make sure that the board has notification of the individuals going into the patient homes. And so this was discussed with stakeholders during the meeting, and there were the similar concerns to the physician's order, and is that really necessary? Is there a better way to address the concern that the board has and also not require a license? Is there another way to streamline the process for those patients who have, for the optometrists who have established patients, if something happens to that patient where they can't go to the brick and mortar, is there a way to streamline it so that optometrist would be able to still see that patient? And so the kind of third option that the committee and the stakeholders would like to put forward is, instead of a separate license and instead of requiring the physician's order, if they could create a notification requirement in the statute that if they're going to do the services for homebound patients, prior to doing that, they would notify the board of where they're practicing. So we envision that similar to an online transaction. Just before they go to do it, they would create an online, notify us of the patient information, and not the confidential patient information, just really the individual's chart ID number or something, and then adding in the section for an audit authorization for the board. That way, if they go and they notify us, okay, I'm going to go and do homebound services, they go and notify us of that information, and then we would be able to audit those records if we have concerns and make sure that it's working all right. And so the request was to consider putting audit authority in 3070.1, and also to remove the recommendation for the physician's referral.
And Dr. Turetsky, I have a feeling I've asked you this 20 million times. Is part of the patient referral tied, though, to reimbursement from insurance? Or no? Does insurance require a referral? So if we take that away, does that mean that some folks won't get access to care because the physician won't get reimbursed for the?
My group is required, if we're going to see a patient that has Medicare or Medi-Cal, and they're in a nursing facility, we have to have a physician's order to do the billing. I don't know how that would pertain to homebound care. You'd also have issues too with if we're dealing with Medi-Cal patients. One, that provider would have to be a Medi-Cal provider, and if the patient had Medi-Cal, say through VSP or IMED, would that provider meet their eligibility to provide in-home care?
So, yeah.
So I can be a Medi-Cal provider, but until, in IMED's case, until I have their blessing to provide mobile optometric services, I can't provide care to their members in skilled nursing facilities. So our group has that authorization, so.
And this did come up during the discussion, and they said that there is a difference between residential care and what we're proposing.
Yes, there is a definite difference.
Yeah.
So what's the difference?
When you're dealing with facilities that are licensed by the state under certain statutes, then that's the main difference. You're dealing with facilities that are licensed by the state. They have oversight. They're either licensed by the Department of Healthcare Services or the Department of Public Health. There are surveyors that are actually monitoring the care that's received there, and the charts that on the patients that we see, those charts are reviewed by state surveyors. That's not going to be happening in somebody who's homebound.
Yeah, so, because we're talking about providing in-home services for people in their home, correct? I just want to make sure.
Right.
So I guess my question is, and before we do anything else, we need to make sure that we're not cutting people off because their provider is not going to be getting reimbursed because the insurance is not going to pay for it.
You will be cutting people off if you have an elderly person who's taken a fall, they're recuperating at home because they've had hip replacement surgery, and they have Medicare. And the doctor who's going there doesn't accept Medicare. So that person would not be able to have their vision, their eye health exam taken care of because the provider might not accept Medicare. They'd have to pay out of pocket.
This seems like a logic problem to me, that there are two barriers. There's a regulatory barrier and there's the insurance barrier. So let's get rid of the regulatory barrier. That's within our power.
Right.
Whether there's an insurance barrier or not, that's not our problem.
And I also don't think it's fair, though, to tell a certain provider that, hey, you got to sign up to take Medicare, you got to sign up to take Medi-Cal, you got to be on VSP and IMED and March Vision, or we won't give you the authorization to go into somebody's house.
That's an insurance end.
That's the insurance end. It's not our end.
Right.
So.
And the other thing is, because of this logic problem, I don't want the insurers to say, oh, we're not going to pay you because the Board of Optometry says it's illegal. Let's get out of this equation, and let's remove our barrier and let the other sort itself out.
There was a lot of discussion that if they required a referral, that would actually create more barriers. And so this option was a better way of leveling the playing field.
I have another question, though. I heard that we want them, the optometrists, to give us notice that they're going to this person's home. That strikes me as an additional layer of paperwork.
Yeah, wow.
Why? I mean, we could have a requirement that they keep adequate records of which homes they visit and the locations and the patients, and we can audit them later, but this constant notice for every time they go out seems...
The fear was that the senior population is probably more vulnerable for scams, and if we at least had this online transaction of us being able to verify, yes, in fact, an optometrist, licensed practicing optometrist is going to that.
Because so part of it is that, if you need in-home physical therapy or in-home nursing or whatever, that is usually done through either the primary care physician or a hospital, right? So when they come into the home, my mom's had this, they come in with their computer, their medical record and all of that. And so they're responsible to someone else. I think we were afraid if we have no way to track it, then, someone could start going door to door in a senior community. I'm going to give comprehensive eye exams and we have no idea. They could be on probation, they could have had their license suspended, whatever, and there's no way for us or the state to know what's going on. I think it's a consumer protection.
And by them doing this allows us to do periodic audits.
But my question was, when we talked about this lead reg, the reason why we talked about another license was because you could charge an additional fee to help pay for the enforcement of having a new program. So if you're gonna go in and audit, it's gonna add another layer of work to make sure that we're maintaining the standard of care. How are we gonna pay for it?
There was discussion that there may be some nominal fee, and they were open to that, but they were completely opposed to having a separate license.
Why? If it's optional, was that COA that's opposed to it?
COA and others that were in attendance.
We have eye
Well, you know why?
exam, 2020 oversight, the Optometry Association, Western University. We had good representation. Kat, would you mind speaking and providing a perspective as discussed?
Licensure didn't have a position on the separate licensure, but I remember the conversation was that there are other spaces where telehealth is provided and separate licensure isn't required. I think was part of the conversation, sort of in parallel with other health professions where you provide mobile services and you're not required. That was what I recollect. I think we weren't active in that piece of or didn't have a position in that piece, but we did talk about sort of parity with other professions. Sorry, not telehealth, mobile clinics.
Yeah, but a physician though has a pocket license. Their license allows them currently to practice, I'm not arguing that they can practice anywhere. Currently, an optometrist license, you are tied to your location. So we're actually opening it up more, in my opinion, for optometrists to have different places to practice. And if we're going to do that, we need to protect the consumer. The way you protect the consumer is by being able to monitor where these people are practicing. There's a price tag to that. And how are we going to pay for it? The other opportunity is you raise the fees on every single optometrist, which I don't think is fair. They're not choosing to do this. So if you're making the choice to go in and provide in-home services, there should be a nominal fee you pay for a little thing on your license, and that offsets the cost. Otherwise, that cost is going to get carried on at some point to every single licensed optometrist in the state.
Yeah, and to clarify, I think it's not so much of the need to create the license. The concern was how do you fund being able to audit? And so there was discussion about providing a fee on the notification, which would cover the cost of the audit. When you have a license, the license is renewed, and there's a lot more costs associated with maintaining an actual license, where you might have a situation where an optometrist has an established patient and they don't want to do this on a normal basis. They want to be able to handle this patient, and so a license might not make as much sense as requiring them to notify the board, attaching a fee that's determined as necessary to audit, so you can do that without requiring an actual license, I think was the thought.
But what if going forward, there's an optometrist who decides my business model now, all I'm going to do is do in-home, homebound care?
So it would just
Then-
each notification that
Is going to get a different fee?
No,
Every
it would
time
be
you
the same
notify, if
fee.
I'm going to go into Mark's home, and then I'm going to go into Glenn's home, I'm going to get charged to go here, and I'm going to get charged to go there?
Right, so because the thought would be the cost to audit that location. So if they're going to multiple locations, they would be paying
I
the
think
cost.
that's
of
more
location.
complicated than just saying, if you want to do homebound care, it's an extra $20, $25 that you have to pay, as opposed to nickel and diming someone every time they want to go in and see someone.
And this is the feedback from the people that are actually in
Yeah.
the industry, and this is what they're saying. They believe there's going to be a very small market for this. And from their perspective, having the audit fee, they were open to, but having a separate license, they would oppose.
I think part of the conversation was that sort of maybe take it in a direction was that it was not about the practice license or the practice of optometry having a separate license. It was about the location by which you're, thank you. So if there was a fee, I think, and there was discussion that it was separate from the license of optometry, so your actual practice license, it was a different type. So I'm going to refer to the association.
Everybody's looking at the association, and I have to apologize. I was not a part of this work group or this discussion. They let me out of my room just this week to come see you, and I got a very brief briefing. So I just, don't hold me to this. Kat was absolutely right. Licensure is so different than anything else. You're being licensed by the state to protect the public, and that you showed your ability to do something, whether it's provide eye care, accounting, or whatever. That is very different. And that may just be vernacular. I had no idea what the cost would be to enforce something like this. It is unlikely. I could see doctors, I don't know, wow. I don't know what the cost would be. I don't know if by putting a cost on individuals to treat homebound folks, they're homebound not because they put themselves there. It could be economically to a disadvantage for that doctor to make that call, to get engaged in that business. I don't know the economics of it. But certainly we want to provide, you all know this, provide care to everyone who wishes to have care and in any setting that is appropriate and safe for them. And really, from what I gather, it was trying to avoid having folks try to sell homebound, meaning seniors, and they're not all seniors by any stretch, services that they don't need. And I think that's where the audit came in and so forth, to make sure the public was being protected. Does that kind of answer your question, Rachel?
Was was ARP there? Were they invited?
They were not there.
Did we invite them?
I don't believe so.
Were these all lobbyists and governmental affairs people at this stakeholders meeting? Or were there actually?
There were schools as well as the schools.
Like not actual, we didn't, I think it would be interesting I think I would like to see us reach out to ARP or some senior groups that deal with the senior community, maybe some folks in the disabled community as well that deal with folks with disabilities, to get their perspective on it. And I'd also like to get the perspective of optometrists, not, no offense, but not just their lobbyists or their governmental affairs folks, but some up, and maybe COA can put us in touch with optometrists who deal more with have more seniors within their practice to get their input, because I would push back on that there's going to be a really small percentage. I think the percentage of seniors who will want to have services coming into their home is only going to increase. And I don't want to have this discussion and then we're having to keep amending things and I'd rather try to do this right and cohesively the first time than try to piecemeal it later on.
Just one of I personally don't think it would be a big thing, that it would be widely used, because it would need to be in senior communities to really be advantageous to do this on a very, very large scale. And you usually have to be contracted with those communities. One of the reasons we specifically minimize dealing with they're called RCFEs, residential care facilities for the elderly. They usually impose so many stringent requirements on you that it's extremely difficult to get in there. You have to have $1 million insurance coverage on every vehicle that goes in there. You have to have all types of background checks performed. They make you jump through a number of hoops, and we'll only do this with some of the larger facilities, because if you're dealing with something that's got 20 residents, it's just not worth it. There's already a lot of protections for the senior communities that are built in by the companies that manage and run those communities. It's going to be the folks who broke a hip and they're at home, or mom can't get out of bed. So you're going to be doing this more on a local optometrist going to see a local resident in their home. That's going to be the main thing on this. And it seems sort of crazy to say, okay, we're going to charge you $10 to go see Mrs. Smith, and she's going to pay you $50 for your exam. It doesn't. I don't know. And that doesn't make sense to do that. I just don't see this happening on a very large scale with the homebound issue. I do see it on a large scale if we opened it up to corporations
See,
and things like that.
That's my question, is if the goal is at some point then to open it up to private companies and mobile clinics and all that,
That's where it'll take off.
But so I think figuring this part out and making sure that we've got this part done, because if suddenly we've got mobile clinics that then can come in, and I'm not even talking about a senior community though, I'm looking at even where I live. I mean, our next door neighbors, or my next door neighbors, they're awesome, they're senior. I mean, I think there's more people staying in their home, because the growing industry is all of this stay at home, bring in care into the home, maybe we need to talk to, that's why I think getting someone in from AARP or one of the senior associations that really focuses on the demographics would be interesting.
Let me give you something that happens. It's at least once or twice a month our office gets a phone call from somebody who's homebound, or their husband's homebound, and my husband has glaucoma, he can't get to his ophthalmologist to have his pressures checked. Can you guys come in and do that? No, we can't, because we can't go to a private home.
Because of the state.
Because of the state. We've had ophthalmologists that'll call us and say, hey, can you do a pressure check? Can you do a follow-up on what their optic nerve looks like? I mean, we've got portable cameras, things that we can bring into a house, and we won't do it because it's illegal.
Because of the state, because
because the board doesn't permit.
So that's what we have to fix.
And remember, this is in 2 phases. This first phase is for the homebound for our statute. The next phase looks at
Yeah, exactly.
the concept.
That's why I think
First
this
phase-
first phase.
First phase is going to be small, and it's going to be to a population that's really going to benefit from the service. The larger phase is where we're going to start.
Yeah.
That's going to have a lot of questions involved.
Yeah, the doctors who were in attendance, and there were some nonprofits, I just didn't write all of them down. Their feeling was this first phase is really going to be those individuals who have an optometrist, who for whatever reason have some medical condition that precludes them from getting to the office, and they get a request, can you come to my home? And this would allow them to do that. And for this phase, they do not believe that a separate license would be the best way.
Okay, talk about something next.
Jessica mentioned, so what if you have a private optometrist who has a patient who can't get in and you're going to go to their home? Well, that's assuming that you as the private, or I as the private optometrist, is equipped to examine that patient in the home situation. You're not going to see a bunch of private optometrists equipping themselves for the occasional homebound patient. Therefore, I think there needs to be some kind of licensing to control, the kind of equipment that we're going to take in. So I'm a private optometrist, my patient can't get in. Hey, I know a company or a doctor that specializes in this, and that's who I'm going to have go see you. And they're going to report back to me. So there can be kind of a referral basis situation, but this individual patient auditing thing, you're not going to have any doctors wanting to do this. It won't go. It's not going to happen. As an optometrist, I'm not going to do it.
And how could you, wouldn't that be a HIPAA violation if there's been no complaint filed? And,
Yeah, so we brought that up as well, and that was one of the things that I had mentioned, that if we did require, give authority for audits, we would want to have the patient sign off on a release similar to what we do for complaints, where the complainant would sign a release of medical records to the board, so it would include something during their paperwork to include that release to the board.
boy, can I please get out there and start doing these homebound exams?
Okay, so this is what a mark, and then bring our closure to this.
So it's clear that this is going to require more discussion, but
Thank you.
I want to go into 2 thoughts. One is, I start from a different assumption in that, when this happens, particularly with homebound seniors, I don't see a pack of optometric wolves kind of swooping in packs going after our homebound seniors. I mean, optometrists are probably 95 to 99% compliant with the law and their scope of practices. So, we should be careful as to what additional regulatory controls and obligations we create. And then, now I can't forget, I forgot my second thought. Oh, if there are auditing costs that our board is incurring, I'd say increase the fees for everybody. I mean, if it's becoming that big of a practice, then increase our licensing fees for everybody.
So what I'm hearing is that we may not be ready to authorize the work group or the committee to move forward to draft and vet language. It sounds like we have a lot of unanswered questions and we need to review this further, adding more voices to the discussion. Am I hearing this correctly? Okay.
Yeah.
So we will table for now the request to move forward, and we'll go ahead and ask that you go back to keeping the conversation going and adding the stakeholder population. How's that? Okay.
Okay, next, at Ledge we discussed merging the practice acts between optometry and the registered dispensing opticians. You can see the review attached. So we'd like to bring the amended to the full board for your consideration.
Discussion? Folks are trying to call that link up.
So, I did review the our council's review of the two acts and how we can make them consistent with one another and noted discrepancies. It looked fine to me. I mean, I refer to the scrutiny of our legislative, our own general counsel's office. It's a good idea.
And this takes legislation, correct?
Correct. So with the combining of the acts, and this was also reviewed with the DOC yesterday, and they reviewed the same document, except the one difference that was changed recently was the combination of the Rulemaking Authority. So the Rulemaking Authority worked within all the different sections, and so we wanted to merge that into one. So because we have so many rulemaking packets pending, that we want to be able to cite one Rulemaking Authority. So it's just still technical in nature. We didn't want to do any substantive changes to any of the sections, so we're aware that there's still sections that need to be discussed and pushed through. But the thought was if we can combine this, as our legal counsel has done, to address the technical changes that needed to be made, then we could put it in an omnibus bill and get this portion done, and then discuss the specifics for the language at a later date.
And to be clear, you've reviewed.
Yeah, I created it, and just to be clear, it wasn't combined so that the various sections, for example, in professional conduct for RDOs and optometrists were to be consistent. It wasn't combined that way. It was just combined to keep each separate section, substantively the same, except for the Rulemaking Authority. We combined those. So it's really just a matter of
Organizational structure.
And I also made some notes about the inconsistent provisions.
You're moving it from the med board over to the optometry board. So I think that puts it all under optometry as opposed to under the section pertaining to the medical board.
Correct. So the action that you would like
I guess we'd like a motion to direct staff to continue to introduce legislation to merge the practice acts.
Correct.
Do I have a second?
Second.
Discussion? Board members, to my right? Left? Public?
I think I'm just going to say what I continue to say, which is as long as it's technical, I think we don't have any concerns and we continue to enjoy the ability to have that conversation, but we start to venture into a non-technical space, building palpitations across the industry.
The California Optometric Association, we share the same sentiments.
Having worked on combining other acts in other areas of law, I would also request that we get that same agreement from those of you in the regulated public, because we don't want you guys suggesting substantive changes in this process as well.
Sure.
All right. Ms. Brandbach.
Aye.
Dr. Tretsky.
Aye.
Rachel Michelin, aye. John Burke.
Aye.
Dr. Chaw's absent. Ms. Garcia.
Aye.
Dr. Carucci.
Aye.
Deborah McIntyre.
Aye.
Mark Moradami.
Aye.
Ms. Berber.
Aye.
And Dr. Wong is absent. It passes 9-0.
Okay, thank you. Children's Vision Work Group.
I'm going to go, and then I'm going to turn it over to Glenn. So, Children's Vision it's still alive. It's in Assembly Appropriations Committee. The odds of it getting out and getting passed out of the House of Origin by the end of January is slim to none. But we did meet with Assemblywoman Burke's staff. We're looking at strategies on moving forward. We're still going to continue to push forward with the legislation, and hopefully Glenn will share a comment he received when he was with a couple members of the legislature about the importance of pushing forward on these types of things. We will probably be introducing another bill, letting this bill die. But we don't know yet. It's really up to the Assemblywoman. It's her discretion as to whether or not she will continue to pursue legislation. Hopefully at the January board meeting, we'll have a better report to give you all. But please be assured that if we do move forward, Glenn and I are committed to all the discussion this board has had, that we are not going to change the substance of the bill to adhere to any folks who don't agree with us on the importance of comprehensive eye exams for children. But I would ask that particularly those of you who have any access to data, that you share some stuff with us, whether you know coverage for children, whether you have any stories you could share, or you have colleagues, particularly those that are on the licensee side, so we can start collecting the stories, because we will ask all of you to make a huge commitment next year, should this bill get reintroduced, to assist us in lobbying this legislation at the Capitol. Glenn and I, it's a lot of work, and we're going to need a lot of help, because we'll have a very short amount of time to get it done. Should the Assemblywoman choose to introduce it, it's a timeline of February to August, and that's it. And you have to get it through both houses and to the governor in that short amount of time. So with that, I'm going to turn it over. Glenn, do you have any comments?
So on October 28th, I was invited to attend the COA advocacy event, in which they were honoring Senator Holly Mitchell and Assemblywoman Autumn Burke. And so I did have a chance to speak with one of her staff members, as well as Assemblywoman Burke. First off, I want to make sure that we have a chance as a board to thank Assemblywoman Burke's office, as well as her staff, all the work that they did in supporting what we were trying to achieve. In addition to that, I did have a chance to speak with both her and her staff about their motivation around the opportunities that exist with Children's Vision, and they were still very much on board, and we are looking forward to continuing to work with them on introducing the legislation, and so we'll be bringing back more information in the future.
All right, consumer protection. Yes.
Yeah, okay. So the goals of the Consumer Protection Committee will look very familiar to you, because we have adopted as our goals the board's strategic plan goals under its enforcement objectives, and that is on that link that is in the general report. I won't go into what this board decided as to what its enforcement objectives were. In addition to those goals, which are, there are 9 of them, if you look, the board requested that the staff put together a chart as to what's going on with online infractions. I get it that online infractions is a target that numerous boards are working on, but this is our contribution. And that chart, I'm sure, will be shared with everyone. I also want to, as closing, acknowledge that although our committee is the Consumer Protection Committee, we acknowledge that the entire board is involved in consumer protection as its foremost goal, and that our focus is primarily on enforcement matters.
Thank you. And the partnership task force with the medical board will be connecting with you, Mr. Mordomi, to help move that forward.
Okay, great.
Thank you. Public relations and outreach.
It's pretty self-explanatory, but the committee met, and it sounds like staff is well on their way to implementing the outreach campaign. We have a pretty comprehensive plan to roll out newsletters, social media, all designed to reach many different audiences. So I think we're on track there.
Great. And no asks of us at this time. All right, thank you. And practice and education.
I'll give you some quick updates. They've met a few times since the last board meeting. They did develop objectives similar to the other committees, and those are outlined in the materials. A couple of things that they also did is they're helping now with staff when we get requests for audits. A lot of the times at the courses that they approve, they don't identify type of course it is on there. So under the regulation, there's a set number of criteria that the type of course that it is. So if it's in management of ocular disease, or if it's in the other items under the regulation, the staff doesn't have the knowledge. When we get a course with a title, Monterey Symposium, this just as an example, and we're looking at slides, and the staff doesn't have the experience to be able to say, okay, well, this is clearly management of ocular disease here, and this is not. And so what we had asked is a couple things when we asked that the committee assist in determining what course that falls under. But long term, we're also asking, the board had approved an application for the course providers. And what the committee is asking that the board approve adding a box indicating what section that they fall under on the application. So that's the question for the board, is if they approve of that. And Dr. McIntyre, as part of that committee, you want to add anything that I may have left off, but
That's it. We just need the categorization. It'll make our job a lot easier.
Is that something that the board has to approve, or does the executive director have the authority to?
So I can't, because it's on the application, and the application is incorporated by reg. And so to make a change to that application, we have to go have the board approve adding that box onto there, because anything for the application has to be approved by the board.
Through regulation, or? Through
regulation, because the form itself was approved by the board. The application itself is still going through the rulemaking process, so it should be pretty simple to put in the category. It's just having the board approve adding that category. And also from—
Would you like a motion?
Yes, but to add the category and also to the number of hours that they're requesting. Because that's another thing that staff's falling under, is they don't know what amount of hours is being requested. And so we're just asking to add the category and the hours.
I have a kind of tax question about co-approved courses. Do they go through the same process or no process?
No, because co-approved courses, they, under the regulation, have essentially a blanket authority. If they're co-approved, then they're approved, and we don't have to verify that. It's really of the ones that aren't co-approved, that aren't through the associations, because whatever in the reg as far as who has the blanket authority, It's where the board is approving them or those that aren't under that category.
One thing related to communicating with educators, it could be an opportunity that we do a better job explaining that to get course approval, they have more than one option, and that the quickest option is going to be for them to have already obtained COPE approval, and then explaining that there's a timing issue around if our committee will approve it.
Right, and the ones who submitted, we have some pretty standard providers, and they would prefer not to do COPE. They're fully aware of the COPE process, and they have opted not to do the COPE process. They want to go through the board approval process.
If we're finished with this last report, I want to go back to my report, and then I have a general question. Whenever you are ready.
Okay. Anything more then?
Like you said, are we going to go through with what we need as far as?
Yeah. No, that's why we're going to go more comments first. I want to get to lots of comments. All right. Is there a motion on the table?
I'll move that the CE approval form be modified to include the categories of education approval required or requested and the number of continuing education hours requested.
Second.
All right, any further discussion from the board? From the public? Secretary?
Ms. Brandwein.
Aye.
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Ms. Burke.
Aye.
Dr. Charles absent. Ms. Garcia.
Aye.
Dr. Calgucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Mardani.
Aye.
Ms. Ferber.
Aye.
Dr. Wong is absent. Motion carries 9-0.
Ms. Murdomy, you wanted to go back?
So, as one of the goals or objectives in the Consumer Protection Committee report, in the Consumer Protection Committee, was outreach regarding cosmetic contact lenses for Halloween. Some of those objectives were for this Halloween. I was going to ask staff what happened.
So,
And a question after that.
okay, so for cosmetic contacts, there was a lot posted on social media. We also had an interview with Dr. Turetsky. He was on an interview for cosmetic contacts, and so we were able to roll out that part of the plan. So do you want to add to your interview that you had?
Who were you interviewed by?
I was interviewed by iHeartRadio Sacramento. Dozens of people must have heard it. And it was a very short interview. It was, I only have the raw copy of it, which was talking to the interviewer beforehand and afterwards, but the main body of it couldn't have been more than a minute and a half.
There were also DCA press releases that went out as well, and DCA reached out to all the media to obtain interest, and that's when we had got the interest to interview Dr. Turetsky.
And did we upload or provide a link to the FDA?
The FDA information that was available, that's still being rolled out as well. There should be links on our social media page. There was a lot of articles related to the cosmetic contacts that DCA put out and that we put out.
There was a video, wasn't there, that FDA had?
Yeah, and so that video, DCA had recommended not using that video, so we didn't proceed with that portion of it.
Why not?
They felt it was pretty dull, and they were looking at creating a video that is more, less dull, but. But it's not, just because Halloween's over doesn't mean we're stopping. We're still developing it and to make it more catchy.
Well, I guess my response to DCA is, don't let the perfect be the enemy of good, in that, I'll probably, if I held my breath, I'd probably pass out before the DCA video was available, and the FDA video is available now. So that's my comment on that. Switching subject, a larger comment I have about the committee reports. This is the first time we've had committee reports. It's a great idea, Madam Chairman. For the next committee report, I find it very helpful under the DOC committee, the the heading of requested actions coming out of the board that I can think about beforehand, as opposed to having kind of requested actions popping up here at the meeting, if possible.
Sure, like that. You got that? Yeah.
Oh, I apologize. Apologies to the great legislature.
All right, so let's move through. We're going to save your interview for cake time at the end, because we're eye-hearting, wanting to hear and know. And move on to agenda item number 10, discussion and possible action regarding BMPC, unlicensed practice and advertising. Ms. Sieberman.
So, as you all may recall, we had proposed some changes to 3040, our unlicensed practice statute. The thought was to add in offering and to also make the statute more concise. After receiving concerns from stakeholders who also presented at our last board meeting, the board had opted to table this discussion, request it to be removed from our sunset bill, and take it up at the next meeting, which is today. And so with that, and based on the letter that we received from stakeholders, legal counsel and our Deputy Attorney General, who has had to leave to catch a flight, we looked at the existing statutes, and we determined that it was not necessary to add offering. And to clarify, when we put offering in, it was never that we felt we wouldn't be able to uphold if offering happened. Because of how the existing statutes are, with 3006 defining what advertising is, we believed it was sufficient. The reason why we wanted to add offering was merely to clarify that we are talking about offering, and while it is not technically the same for an advertisement, when it is defined in 3006, it is covered. So it was merely just to cut down on the questions from the respondents, from the attorneys, if offering was needed. So with that, we do not think that changing that part of the law is necessary anymore. However, we still do recommend making a couple changes, one to 3040 at the end to make it more concise. So we're looking on page 2. We still do recommend to strike display a sign or in any other way, because that is covered under the definition of advertising in 3006. And then to just make it more concise of what the underlying language is versus what is struck out. Yeah. We also wanted to make a change to 2556 to apply to those offices those disposing opticians who were not licensed. So the recommendation from 2556, the change in there was also developed with legal counsel and the Deputy Attorney General liaison. So then the ask would be, if the board approves, then we would move forward and try to pursue either, we're hoping through the omnibus bill as well, because we feel that this is more technical, and if not, then to proceed with legislation, other venues.
And legal counsel is reviewing the
Yes, I worked very closely with Justin.
And our Deputy Attorney General as well.
Comments on the board? Well, yes, Mr. Mordoni.
Just when you say the omnibus bill, do you mean the bill we just discussed about combining the two practice acts? Because this sounds substantive, and I don't want to make sure we don't make a substantive change in that process.
We can try to do the omnibus bill, because the omnibus bill is not just DCA, it's any technical bill for the Senate B&P committee.
Okay.
And so what happens if we believe it's technical in nature, non-substantive, we can request that it be put into an omnibus bill.
I see.
If it receives any kind of controversy or any objections, typically it's taken out of the omnibus bill and we'll proceed it with something else.
Thank you.
Dr. Kawaguchi.
So I have kind of a broad comment about unlicensed practice. There are rapid changes in optometric care that are going on within California right now. And so the changes that we're proposing right now are not very substantive. I don't think that that's substantial. And I just wonder if we're missing an opportunity to really see what is existing out there currently, or we're making assumptions based on things that we've already experienced or have been reported to the board.
Can you give an example?
No, not really, because that's the issue is that we saw a very fast, large rise in RDO applications after the completion of AB 684. And with that, there is now an influx of new providers. So I don't know what's completely out there. There's no way for me to know that without us possibly investigating or seeking to understand what's happening out there. So that's my only worry about making changes now is will we need to make changes maybe 6 months from now or a year from now again. Whether it's because it's not encompassing enough or something new pops up that's not encompassing in what we're talking about here.
So I think that the language itself, the intent is pretty broad, especially in 3006 when it defines what advertising is. I mean, it does in 3006 list quite a bit of examples, but it also says, or any other way call attention to their services. So it right now is fairly broad for that reason. So I don't know what other language you would put in there to make it more broad to encompass things that may come.
I'm not sure. That's the one that I
So are
think
you thinking then, Dr. Kawaguchi, that we research other boards and their regs to see where some of their services might be more broadly stated, or what are you thinking as a next step?
Well, as an example, we had discussed earlier our desired connection and moving forward connection with the medical board.
Mm-hmm.
So that could be an example of that. Is there alignment in optometric regulations along with physicians so that it makes sense altogether and that the consumer is ultimately protected?
So maybe take this to the task force with the Met Board, add this as well as a discussion item. That would be consumer protection, likely starting the conversation between the various different committees. That one would likely be the one.
And I know with the Deputy Attorney General, she did look at the medical board statute as well, because we have some overlapping issues when it comes to unlicensed practice. And so they are very similar for how they're worded.
Can we run it by Ms. Webb?
Yeah.
Let's do that. The medical board has their own on-staff legal counsel, so we'll go ahead and run it at least that direction. Dr. Kawaguchi, does that help? Mr. Mordomi, and then I'll come down to this side.
That's fine. I was going to, since I'm a lawyer, I was going to offer a lawyer's solution.
Okay.
Whenever legislatures, regulatory boards draft legislation, particularly in this era, they always think about, or they usually try to think about, well, what's the next step in technology, right? Because we can't predict how technology might change and how the regulations are behind. So Dr. Kawaguchi's concern is, we think about it, we should be thinking about it for every regulation we pass. That being said, I would look to our counsel and say, okay, we need to be forward-thinking, look at this language, and will this language cover new and emerging forms of advertising? And I think that's a lawyer's job to say, yes, we'll draft it in a way so it encompasses unforeseen ways of advertising.
Yeah, now's a good time for me to say what I wanted to say. What I wanted to say is I want to be very careful with changing this wording, advertiser hold himself or herself out as an optometrist. That language is used in other statutes, boards and bureau statutes, but there is a California appellate court case that interprets that very broadly. So that makes it the rule of law, and the rule from that case, it's California Association of Dispensing Opticians versus Pearl Vision Center, 1983. Basically, I can tell you what the facts are, but it broadens that to mean an unlicensed person cannot advertise in any manner that implies that the unlicensed person is furnishing the services of an optometrist. You combine that with the definition of advertising, which is very broad right now. I think that covers a lot.
Okay, so that's good news.
I just want to.
But it's very broad.
Anyone down on the right side? No? Okay, motion on the floor. No?
What motion do the staff want?
So it depends. If the board approves this language that was developed by legal counsel and Deputy Attorney General's office, then we can move forward with it. Or if you want to do, as Dr. Kawaguchi and Ms. Grandmine were suggesting, to reach out to the medical board and their legal counsel and see what else is out there to be forward thinking. It really depends on where the board wants to go.
I'll make a motion. Move that we proceed with the language. At the same time, we consult with the medical board and whatever else that was suggested as to other ideas or other language.
Is there a second to the motion on the floor?
I'm second.
Okay, any comments? Motion on the floor? Yes, Dr. Kawaguchi.
So does that mean we'll potentially have an opportunity as a board, should we uncover information through the communications with the medical board, that we'd be able to bring back to the board?
Yeah, so then it would be pending legislation. So if we do it in our January meeting, or if something comes up sooner, or in between meetings, it goes through the normal legislation process. So if at any time we wanted to propose amendments to the legislation, the board would have that opportunity. And since it is pending legislation, it falls under the exception to the 10 days. We would have to do the 48-hour notice meeting. So we wouldn't have to wait that full 10 days. So there's definitely various mechanisms in place for the board to continuously provide input.
No public comment? Madam Secretary.
Ms. Brandbein.
Aye.
Dr. Tretzky.
Aye.
Ms. Michelin. Aye. Ms. Burke.
Aye.
Dr. Charles absent. Ms. Garcia.
Aye.
Dr. Kawaguchi.
Aye.
Dr. McIntyre.
Aye.
Mr. Mardani.
Aye.
Ms. Ferber.
Aye.
Dr. Wong is absent. Motion carries 9-0.
Thank you very much. Next agenda item, 3077 branch office license. Ms. Ziegerman.
So it's part of our strategic plan to look at all of our licenses and determine the necessity of them in looking at the protection of consumers. It was also a response during our sunset process. The legislature had asked us to also look specifically at the branch office license. So that's what you have before you. Staff did some research on the background of the branch office license. We found some case law that suggests what the legislative intent of the branch office license was, and I quoted some of that case for you. And it appears that the branch office license was developed to make the profession more professional. So for the profession, and also to avoid the evils of competition. So with that, I wanted to also provide some more information on, obviously, you looking at the Federal Trade Commission, the FTC, and Little Hoover Commission, and the real purpose of creating a license, because creating a license is not intended to be developed for the profession. It's not intended to put unnecessary barriers on it. you should require a license when only necessary to protect the consumer. I think when the branch office license was developed, the concern was there was some misleading information from one of the doctors, and they owned multiple branch office licenses, and they wanted at the time, COA might be able to speak more about this, but the concern was that they wanted to make it more professional and less commercial. And there is also some concerns that I've heard over time about the need to hold the owner of the business accountable to the patients. So this was developed in the 50s. Subsequent to that, there was 3110, which is unprofessional conduct, was put into place. There was false and misleading statutes that were put into place to take action against people who are getting false and misleading information. So a lot of other statutes that are designed centered around consumer protection were put into place. And so if we had a complaint where there's a provider providing substandard care in an office, and it happened to be an employee of an optometrist who owned multiple locations, we would look at taking action against that one optometrist providing the substandard care, and potentially looking at the owner, the optometrist, if he knew or assisted in the violation. So there's other mechanisms that were put in place after this branch office license law, and so we wanted to provide that information to the board. And as you all are aware, the intent of a license is solely for consumer protection. As far as the program standpoint for enforcement, we don't see a lot of the enforcement cases being impacted by whether or not the branch office license exists. We do feel that the consumers are still protected with or without the license. So with that, we just wanted to open up to the board and
Comments?
Question.
Dr. Bresky.
So if the branch office license was eliminated and I'm going to open up 15 offices, what would I be posting in those offices so folks know I'm registered?
so you would still get a statement of licensure.
So you just do an SOL instead for each office. So you'd have your primary office and then SOLs at all the others.
Mr. Morgarmi.
A couple questions. Maybe our council can, who is the Mulford that's referenced in this case? Second question, second statement. As kind of a whim, I said a few months ago, let's get rid of this. And the more I read, the more I'm convinced of that position. Because the day, and this is happening in all professions, including the law, the day of the quaint little lawyer having a storefront operations serving clients, those days are long gone. And I imagine that's the case for the practice of optometry. I am curious as to a comment that Jessica just made about, if you have an optometrist and one of the people that one of the people that works for him commits gross negligence, right? And then you said something about know or consider to know that the optometrist license would be at risk only if that optometrist knew or assisted in that inappropriate behavior. I want to ask about that because I think in other professions, like if I have a paralegal and that paralegal is working for me and that paralegal really blows it, I lose my license. It's not, oh, I knew about it or I assisted in it. It's kind of like, too bad. They work for you, you supervise them, you lose your license.
But you're talking about another doctor. Paralegal does have to report to you, right?
Yeah.
The other optometrist doesn't have to report to the person who's paying his or her salary.
Okay.
Yeah, they might be an employee, but they still have their licensing responsibilities. And beholden to the person paying them, whereas that paralegal is working under your license.
Okay,
I'm right with that, aren't I, with the paralegal?
yes,
Okay.
yes, I just want to make sure I understand what just.
Yeah, because, there's 23 docs that work for me, and I know that if somebody screws up, they would have their license at risk if it was something that was gross negligence. My company's going to be sued along with that doctor, but as far as I know, I am not personally liable for that person making a mistake.
The caveat is under 3110A, that's where it mentions assisting or aiding the violation. And so if the board knew that their employee was consistently giving substandard care and did nothing about it, then it's a potential to look at 3110A. But again, and I think we mentioned this before, that it's clear and convincing evidence, so we would have to prove, so it'd be fairly difficult, but we would try to do proof that if that optometrist knew. But
So I'm sorry, is that in the case, as Dr. Koreski just explained, that the employee is another optometrist or that employee is a technician?
I think he's a optometrist.
Oh, it's optometrist. Now, if it was a technician,
That's separate.
that's separate. That's a great question, because it would probably end up falling on me.
Correct.
Okay, if
Yes.
that's the case, I'm fine with it.
Yes, that's how it works.
I have a
Great, now I won't sleep tonight.
I have a quick clarification. I think Dr. Tereski already asked this, so what I understand, if this were to expand where a doctor wants to go and open up all these locations, they are only paying for one registration, if that is good for all, is that correct? Or
No.
it's per location they have to?
Correct. So currently, 3070 is a statement of licensure, and that requires them to give a statement of licensure for any secondary place of practice, not their principal place of practice. The exception to that is if they have ownership interest in that business, then they have to get a branch office license. So if the branch office license is repealed, then they would just revert back to the 3070 and notify and obtaining a license for that practice.
So, one more question. If we get rid of the branch office license, does that help clear the way for an optometrist to make house calls? Or is there something else out there that they have to apply for and get and post to do that?
So I think with that question, you would still look at 3070, which is the notification of practice and getting the statement of licensure. There's also the health and safety code overall that says that the healthcare professionals can provide mobile services as long as they are doing it by the regulations of whoever is governing them. So we're governing optometrists, so we would have to have guidelines, and so they're referring to our guidelines for mobile practice. Because the only thing in regulation that we have now is that it's limited to schools, then there's still that area that it's not clarified just by getting out of the BOL.
Okay, so that's phase
So no.
2. So maybe it's phase 2, but this gets one employee. This is a step. All right, thank you.
This is step one.
So related to that question,
Yes.
currently, is the practice location considered where the doctor is or where the patient is?
It's, I think, where,
So if the doctor has a license
Yeah.
and has a primary practice
yeah,
and then can have unlimited offices, could they just have statement of licensure for all kinds of different?
yeah, it'd be per location of where they're practicing at. But if you're getting at online,
Where they're going to deliver the care, or is it
correct.
where they're going to go see the patient?
No, I think it's wherever they're practicing. So if they were to go and practice, say at a school, if they're going to go and practice in a patient's home, how it's currently set up, they would have to get the statement of licensure unless it falls under the temporary practice, which is the 5 days and 7 language, but that's all together and not on its own.
Okay, so there's multiple regulations possibly that would be affected by a decision about branch office, right?
Yep.
So we would have to make sure that whatever other ones it's going to touch, that we're all on? Because it's gonna take probably more than just a change of 37 cents. It's gonna probably take changes to other VPCs, right?
That reference 3077 and then some.
Yeah, I think there could be some type of for statutes, but for regulations, that's pretty standard. Once a statute is changed, then there's a quicker process to clean up your regulations because it's rendered really obsolete. And so I don't think the regulations, yes, there's definitely more work to be done, but there's a faster process because the statute is where the authority and reference comes from.
Mr. Morgan.
So, last question. Although I don't really care what the answer to this question is. I do want to ask.
Who was Mulford?
Pardon?
Who was
No, you can have, you talk to me offline. There will be a fiscal implication with getting rid of this branch office license. You cut the fee for it, right? At some point, I'll be curious as to what that dollar value is, but whatever it is, I don't care because.
It's roughly $5,000 a year.
Okay, then I'm glad it's so low because I don't think this is a good law and we should get rid of it regardless of what it costs us.
And to the fiscal impact, because it's not just the BOL that we said we were going to look at, we're also going to look at the statement of licensure. So just throwing this out there that if the board did decide to change or amend any of the licenses, I think all of this, as you know, the plan is to get a fee audit of the entire board and the RDO program in the near future to find, once these changes all settle, to do the fee audit to look at if the fees are adequate enough to support the program. So if something were to happen where we do remove the license and we take a fiscal impact that's going to be caught in the fee audit and make recommendations of how we can make sure that the fund still stays intact.
And then to Dr. Kawaguchi's point, whenever you take a brick out of a wall, it always has its implications. And I would rely upon our council to kind of consider what would happen and what other effects this will have to make sure there are no unintended effects. But I still think it's a good idea to do it.
Thank you. Any other comments?
One,
Yes, I'm McIntyre.
if you repeal the branch office license, then you have to now require the statement of licensure for each of those, no?
No, so you would just, if that's where the board is considering, you would repeal that statute, and then it would mean how the SOL is written now, that statute, it's if they don't have a BOL. And so it would really just revert back to them doing the statement of licensure, there might be some technical cleanup in 3070, because there's no longer the branch office license, but you wouldn't have to add a requirement that now they get it, it would come into play.
Oh, it would just convert?
Yeah.
Okay. And then there would have to, no. Never mind.
Any other comments from the board? Do we have a motion for the floor?
How would, I was going to say, could we recommend that staff proceed with looking at legislation to do away with the branch office license, or would we need to recommend more study before we do that, or?
If you're making a motion to repeal the branch office license statute, I would second it.
I'll make a motion for staff to review proceeding with the removal of the branch office license statute.
What does that mean now with this review? Or do you want to repeal?
I motion that the staff work with the legislature to repeal the branch office license requirement.
I'll second that.
Comments from the board? Comments from the public?
Bill Howe, California Optometry Association. This is an important issue that we've been talking about for a number of years. A couple of years ago at our annual meeting of members that we call House of Delegates, This was a discussion, and the members, the doctors of optometry, the underwriting who practice over the state, voted to maintain the branch office law. It's still been on the table for discussion, and we have held off doing anything because we want to see what the implementation of 684 would go like. You know, what ramifications unintended or whatever might happen. And it is quite likely that it is going to come up again at our annual meeting of members, House of Delegates, to discuss. We have discussed expanding it, reshaping it, but it is a topic, and it's not easy. It is a very, very complicated topic that affects a lot of people, patients, and it's all about patient safety and ensuring that they are getting the care that you licensees are supposed to provide.
Do you want to expand on why?
Yeah, why?
Why what?
If I own 10 offices and I employ optometrists in those 10 offices, all licensed TPA or TPG certified optometrists, where's the harm?
I think along the lines of 684, not to get a position, just discussions along the lines of 684, one of the things that was ensured in the bill is that the doctor of optometry still maintains independent control and judgment. And the patient gets what he or she deserves, needs, whatever, without a company, quote unquote, telling them what they have to do or what they cannot do.
What's the difference then if I employ Dr. McIntyre in my office and I say, you're going to sell 3 pairs of glasses to everybody or your ass is out of here in a week? Whereas me owning 10 offices and I'm telling everybody you do what's best for the patient, I don't see the difference. I mean, I can be the most unreputable individual in the world and have one office.
Well, glasses were not, I'm not about a doctor of optometry, but glasses were not indicated and you are forcing your employee to do so.
But that's what your point is that if I own 10 offices, by the very nature of owning 10 offices, I'm going to do schlock work. Whereas somebody could have.
So let's make it clear, we're not taking a position, we're not making a point. These are things that are being considered and talked about. I go back. It's about the patient. It's about ensuring that you are providing the care that you were trained and educated and licensed to do. You may agree with it, but I just said you may not.
I don't.
That's fine.
No, I just see it as something which is trying to protect the profession and not enhance.
That's not our position, it is a consideration, that's all it is.
As a paying dues member of the COA.
You hear what I said?
Yes. Okay.
Thank you. Ms. Sieberman, you wanted to add?
Yeah, in my memo members, and Dr. Howell is right, as far as the concern also from the stakeholders is that it will become essentially a mill to just pop up glasses that are not necessary. However, under 3110, it is unprofessional conduct to have excessive prescribing and treatment. And so I think that if we were to receive a complaint that this patient received a pair of prescription glasses that weren't really necessary or 6 prescription glasses that weren't necessary, we would gather the documents, send it to an expert would opine, yes, this is excessive, and take action there. So I do believe that there are adequate measures in statute to address that specific concern of the excessive treatment that's not necessary.
Mr. Morado,
This is very curious. Let me ask a question, if anybody can give me an answer. Okay, looking beneath the consumer protection interest that everyone has, us in the regulated community, what are the effects on the economics of the profession? And, who might have an interest in keeping this branch office license requirement because it's better economically for them?
But if you're, you want to jump in? No. If you're a private practitioner and you have your nice little well-established office in a little community, you would probably be against this because somebody that has the ability to offer services in a better fashion, in a more convenient fashion, in a less expensive fashion, could theoretically move into your area and take away some of your business. And it was one of the big arguments back in the 80s when lens crafters first came into California, is that this is a terrible and awful thing because people could just walk right in there and get their glass, get an eye exam and get their glasses. You know, this is going to put people out of business. We can't allow that. And that's what it was. We're going to put people out of business instead of what a great service for the consumers. I worked for them and I know that they did good work.
Because I see, at least what I perceive in the medical profession for doctors, you know, the doctors are at great disadvantage and having these big conglomerates coming in and the doctors having to work for them. Similarly, because you're an optometrist, you can only open up 2 offices, right? So you can't compete against your Walmarts, your Costco's, and so we have more and more optometrists not being in the, you know, they're saying screw working for, you know, just for 2 offices and that limited income. I'm going to work for Costco or Walmart, and that's causing the death of the smaller practices run by optometrists.
I'm going to answer your question too. So the FTC further states in part that competition in America is about price selection and service. It benefits consumers by keeping prices low, quality and choice of goods and services high. I'm not an economist. This is a very large change that we would be initiating from a legislative standpoint. And if we don't understand the potential consequences to our consumer who we serve, then we need to be careful. So because of that, I just want to let everybody know that I'm not ready to make a decision on this because I think it's so large that we need to be careful. In addition to that, we have other things we've committed to already in this meeting from a legislative standpoint. We can't just keep adding and adding and adding. We have to prioritize what we can take on, and this is a very, very large one. And so I'm just not sure that it's going to be something we could see through to the extent that this motion is suggesting.
How do you see this? I don't see it as being that large a thing. I mean, there's not going to be that many ODs with the financial wherewithal to open up, you know, to open up McIntyre Optometry and Turetsky Multiple Vision Services.
How do you know that? How do you know that, though?
I know how much money I have, but I know I can do it. I don't see that as being a major issue because we could still regulate every one of those offices exactly as an individual office is regulated now. The only thing I can see for this is more choices and potentially lower prices. I'll give you one other example too. I have a friend of mine. She has a practice in Pleasanton. She works with autism, dyslexia, traumatic brain injury. She does vision therapy. And she's wanted to open up 3 or 4 offices around the Bay and do that, and she can't because of the branch office license issue. And she wanted to work, you know, 2 offices here one day, maybe 1 office one day, just to sort of go around to them. And she can't do it. She just says it constrains what she's able to do for folks.
Medical doctors can do that, though. They can work a day here and travel and work a day there. And you may have one very good specialist in a certain geographic area, and they have to travel. I have a friend who does the same thing, the same kind of practice. She's confined to where she's at, where her skills could be so used elsewhere, you know, in several offices.
What do the other boards and bureaus under the DCA do, Jessica? Do you have any?
Yeah, so in my cover memo, I also provided input from not only the other DCA programs, but also the other states in the United States. And it appears from other states, it's only Texas and Oklahoma that has a restriction similar to the branch office license.
2 progressive states.
The majority of the DCA programs have no additional license restriction period, so that covers the branch office license and the statement of license that we have. We're pretty unique in requiring separate licenses for practice locations, period. And we weren't able to find any healing arts professions that have, if there's no cap for how many any other healing arts professions own.
Mr. Bordomi, and then I'm going to ask for
Never mind.
comment. Okay, comment from the public.
I can only speak to the conversations we had during 684, to speak to those earlier. As you look at the changes in industry, It really did come down to how the board manages the quality component, particularly for my client who was, at the time, there were insinuations that quality wasn't at the level that DMHC required, which is a high quality level, so thank you for commenting. So I think that it's an important examination of this board's requirement to look at the statement of licensure first, which is, are you meeting the requirements under law, and are you protecting the consumer process? So during that process, we were thoughtful of that and set it aside because it is not an easy conversation to have in the industry, but it is important to remember that all of the healing arts are held to the same standard as all other doctors in all locations, regardless of their practice.
I have a rhetorical question, maybe council can decide to answer it or not, but if the effect of the branch license law is ultimately, if the predominant effect is to restrict competition, isn't the state of California at risk of being sued and having it struck down as unconstitutional? You don't have to answer that if you don't want to.
There should be a consumer protection issue involved, but the perception is it's in there now, there's a consumer protection issue.
Under North Carolina, I mean, this board and each individual board member is liable for an antitrust violation.
Well, this
If-
is state action.
if there's not a-
It's a statute, so you're fine.
Okay.
So two attorneys. Okay, there was a motion on the floor, if I
That
recall.
was me,
And we had the second,
Mark.
so we're ready for a vote.
Ms. Brandwein?
I'm going to abstain.
Dr. Turetsky?
Aye.
Ms. Michelin? Aye. Ms. Burke?
No.
Dr. Shaw is absent. Ms. Garcia?
Aye.
Dr. Calbucci?
Abstain.
Dr. McIntyre?
Aye.
Mr. Mordani?
Aye.
Ms. Ferber?
Abstain.
Dr. Vaughn is absent. Motion passes 5 yes, 1 no, 3 abstentions.
Can I say something or ask something? Since it sounds like there's some discomfort by members of this board, before we take any large steps, I'm wondering if we could get kind of the other absent board members to have input as well, so that we have, I don't know.
Well, they're not here.
Yeah.
Maybe they weren't privy to the discussion.
Okay, okay.
It's not like it's going to happen today. There's
Yeah.
going to be a lot, this will be going on for a long time.
All right.
Come back.
Okay, thank you.
So why don't we close our discussions on business and profession codes with telehealth, because that's not, yeah. Okay, and then we'll go ahead on the update and possible action. We'll watch the time to see if we need to table that or not. So let's go with, if we could please, item 12, 2290.5, telehealth patient consent. Ms. Edelman.
So, just to give a quick background, and I'll turn it over to Ms. Brandwein and Dr. Tereski as well. When we met with the medical board, the executive team, and to discuss the issue of refractions, the concern primarily is always centered around how are you going to make sure that the consumer is educated on the difference between the refraction and a comprehensive eye exam. There was some discussions related to requiring a consumer notice with the information posted there. But another option that was brought up was to look at the statute under 2290.5 about the written consent that's or the verbal or written consent that's needed. And if the board would like to see if we want to open this up to put that, whatever that education or notice would be in this statute, to where they would have to document that they've educated those people receiving refractions that they are not comprehensive eye exams. So with that, Dr. Trusky or Ms. Brandheim or Dr. Trusky?
Well, when we did meet with the board, we met with the board EO, their president, and legal counsel, and Sid, myself, and Jessica were there.
And policy.
Oh, their policy, that's right, the policy analyst was there. It was pretty well understood that it's not going to be something where the boards could get together and say, this is now illegal and you will not be able to do telemedicine, at least in the way of doing a refraction. But the idea did come up, medical board proposed the idea of having the patient essentially sign a release so they know what they are getting and what they are not getting if they wish to have an off-site refraction done by an untrained or an unlicensed assistant who's working for an ophthalmologist at a remote location. It's just a matter of coming up with the wording for that release and then putting the necessary language into a statute, getting it approved.
And to clarify too, it wasn't the medical board who made the proposal, it was staff in the conversations, the medical board staff that had brought it up.
Medical board staff.
But it wasn't vetted to the medical board. We wanted to have a discussion to see if the board was interested in that language prior to the further discussion.
San Diego was specific to the task force and not drilling into 2290.5.
So really, at this point, it would be a matter of just getting thoughts and opinions from the board members and the public as to how we should proceed.
So comments from board members, to my right.
So comments would be discussing what kind of release would be signed. I would think that even more than a release, that there should be some kind of qualifying questions given to the patient, where if they shouldn't be told ahead of time that how you answer this depends on whether you get this exam or not, but do you have diabetes, do you have this or that, and any one of those that's answered in a positive manner negates the ability for them to get a telehealth refraction.
Okay, other comments?
And that they also be aware, I mean, there is going to be an expiration date to this as well, correct? And how are they going to know how long this is valid for?
The prescription?
Yeah.
I would assume it would be 2 years, minimum, just like any other.
And it would be stated there for them to understand that.
Well, that's FTC regulation.
Okay, just want to make sure.
Actually, the biggest challenge is consumers don't know what they don't know. You know, there's a high percentage of people with diabetes that don't even know they have it. So that they could go and agree to this without still not understanding the point of that.
And as an optometrist, I can't tell you how many people come in going, oh, I just need an update in my glasses. And it turns out, no, you didn't. You needed emergency surgery or some, very serious thing. And they thought it was their glasses. How are they going to know this?
It's an awful, this is a terrible thing from an ocular health standpoint. And my own opinion is that the way this will eventually be tamed down and made less of an issue is when somebody sues one of these companies for an enormous sum of money. Because I just don't know how much we can regulate this given the constraints we're under for consumer choice.
And that's what the task force would take a look at.
Yeah.
It's too early to make a determination. Saw down here, Dr. Kawaguchi.
Okay, so this goes back to an earlier comment that I made about being proactive versus reactive. So I appreciate that we're trying to work to be proactive. I'm still, to be honest, I've had a chance to try to look at some BPCs, and I'm still confused how, in certain situations, delivery of telehealth can be legal with our current laws. So I know that we're kind of trying to move along and just assume that it is, but okay, so for example, BPC 2540, no person other than a physician and surgeon or optometrist may measure powers or range of human vision or determine the accommodation and refractive status of the human eye or the scope of its functions in general or prescription ophthalmic devices. So if there is, I'm not picking on any particular organization, if there is a kiosk in California, and a citizen of California walks into this, shouldn't it be that there's a physician OD that's present to at least subjectively refract? That's my first question. If the OD is not licensed in California, then they can't refract in California. They can't refract a patient in California. That's another question. And then currently, we were just discussing this before about branch office license, but a California licensed optometrist must disclose practice location. And so that kiosk would have to be attached to a specific optometrist or ophthalmologist in California. Are those assumptions correct or incorrect?
So let me back up. With the first one about who can determine the measures of the eye. And it's our understanding so far that there are assistants or technicians that are on-site performing the objective testing, which they can do under the direct supervision of an optometrist or an ophthalmologist. That information is sent to the ophthalmologist who is licensed in California under the medical board, and they're providing that service, and they're the ones ultimately writing that prescription and determining the measures of the human eye. So the ophthalmologist is doing that, not the optometric assistant. And if there's cases where there's a line and the thought that is those technicians went over the line to where they are doing more, then that would be the board, medical board or board of optometry would look at potential unlicensed practice of that individual. So far, as far as the optometry side, have not seen the unlicensed practice of individuals. And I can't talk about specific cases, but I think that that's where that other telehealth area is, as far as it's an ophthalmologist who is determining the eye by using their technician, and if there's not a technician, if they're using the app or online, then it's a tool that the ophthalmologist is using in order to determine the refractive status. So that's for the first one. The other issue as far as if they have to be licensed in California, yes, I think it's across all healing arts boards, the understanding, Amina can correct me if I misunderstood, but if they are providing services to California patients, they have to be licensed in California to do that. And so if you have an ophthalmologist or an optometrist in another state providing services to a patient in California via telehealth, they have to be licensed in California to do that. So they are being held to that requirement.
So a question I would have around communication for us to develop is, if I, after reading EPCs and having a hard time understanding how care should be delivered, how can we create communication for consumers so that it's clear to them what they should expect to receive and by who, and things to look out for, so that we would end up getting notified if things are being violated? Without having BPCs listed for a consumer, which is ridiculous, obviously. how can we craft a communication so that there are increased protections in place? I guess
And
that's
this
the
is,
committee.
and perhaps let's take it to the, that's
That's
the task force item.
So
We're not asking for, we're suggesting only possible action, we're not requesting action be taken. So we just are bringing it before the board to get the conversation going, to say we need to continue this conversation.
And the board did approve an outreach campaign for this issue, and the outreach committee is all over that portion of it, and to work closely to develop more materials to address it, and we discussed it, I think, at length at the last meeting, in order to capture those who are receiving these services.
I have a question. Do we know how the other states are handling it? Apparently, the other states are going through this as well. Do we know what they're doing?
Some have proposed legislation and it's either got struck down or has having some complications. There's other states who are set up differently from DCA, to where instead of optometrists under one board, ophthalmologists under another board, they're all under one super board. And so they're able to take action for ophthalmologists and optometrists if they're occurring. So they're set up a lot differently. But I want to make very clear that when we have pending complaints, whether it's us or with medical board, when we look at this issue as far as online refractions or the kiosk refractions, we are primarily concerned with the standard of care that's followed, and we want to make sure that no matter what happens, regardless of the setting, that the same standard is followed. So if we receive complaints and we receive the investigative files, we're able to send that to a subject matter expert to determine whether it meets the standard of care.
So are we in agreement, Mr.
Okay,
Morgan?
finish.
In agreement to continue the conversation and take no action at this time?
So, I'll try to put. So one thing I think our legal counsel should keep in mind is that I do note that this proposed legislation, this idea of proposed legislation targets only telehealth. And a question popped up in my mind, does it create a legal infirmity if we don't say that a brick and mortar optometrist who just does refraction, should that person also give the same notice that one would have to give if it were telehealth? I don't know. I'm just saying that I don't want to create legislation that kind of restricts commercial telehealth for the antitrust reasons. And then the last comment I have is, it's interesting, if I were an attorney representing the telehealth organization, I would probably put in a whole bunch of disclaimers in the refraction exam, and I would probably say, consumer, this is not a comprehensive eye exam, and if you have diabetes or if you have X, Y, and Z, you're on your own, this is not going to cover it. Because, in other situations, if I were to walk into an optometrist's office and the optometrist knows that I have diabetes and other things, and the optometrist doesn't do anything, and I say, just give me a refraction, I think that optometrist is going to get sued for malpractice, right? So similarly, I think that these telehealth organizations may have an interest in having some disclaimer out there. Similarly, if I were representing the telehealth organization, I might put in some disclaimers by saying, if you have diabetes or glaucoma and all this stuff, and you get glasses, you're not going to sue us for malpractice. And I would want to make sure that we be cognizant of that, because I don't think we should allow them to kind of write out their liability through, the fine print.
And to clarify too, that a lot of them do have those similar disclaimers that you're referring to. And also I wanted to clarify that what's before you is not being proposed. We're not proposing any legislation. It was just an option that was brought up and just wanted to bring it to the board. But Ms. Barenfine and Dr. Tresky and the medical board were not proposing anything. We just wanted to open up a discussion.
So agenda item number 13 It's really an FYI, there's no action to take here. We'll let the members continue reading this in their board handbook, as well as the public. Any comments from the public on 13? Okay, and let's go to a very quick update and discussion on...
Wait, sorry.
Yes.
With 13. Come on, come back up. Let me see yours. There it is. Okay, no, because it was brought up by an email by a former board member, do we want to have any very brief discussion on proceeding with how immunization, how optometrists will be trained in providing immunizations?
So I think that if you'd like to have that discussion, we might want to have it on a different agenda item because this is specific to the implementation of the bill, not necessarily what would be approved by the board as far as the training goes.
Okay.
Okay, very quick update on staff outreach and continuing education events.
Yeah, very, very quickly, the request from members was to have staff participate in continuing education events. I provided some overview of the challenges that staff faces in order to travel to those events, but we're looking at alternative motives. If we're not able to get the approval to travel, then we are working with the Practice and Education Committee and the Department of Consumer Affairs to develop webinars to be able to help educate the profession of the board, comment on things that we'd like to remind them of. And so just to let you know that even if we have travel restrictions for continuing education, we are trying to jump over those hurdles, but at the end of the day, we will still proceed with creating a webinar for optometrists.
Thank you. All right, and last but not least, DCA. So we mentioned Christine moved over to the Med Board. We now have a new board division, if you will, that we're soon to hear about.
The new Christine.
The new Christine.
People refer to me as. Yeah, thank you. Thank you so much, President Brandbein, Vice President Turetsky, and Executive Officer Sieferman. Thank you for the opportunity to provide this update from the Department of Consumer Affairs to your board. My name is Chris Castrillo. I was appointed Deputy Director of Board and Bureau Services on October 9th, 2017. I come to DCA with a background in public policy and campaign management, having most recently worked as a legislative advocate where I covered a variety of policy areas including labor, higher education, youth mental health, foster care, health care, and local government. I've worked on candidate and initiative campaigns in both California and Oregon. And while new to the DCA family, I am greatly looking forward to the opportunity to apply my experience and skill set towards establishing an Office of Board and Bureau Services that implements the goals laid out in our strategic plan, exemplifies organizational effectiveness, and provides relevant, timely, and accurate information to all of our stakeholders. Also as a way of introduction, as President Brandbein mentioned, Ms. Christine Lally has joined the Medical Board of California as its new Deputy Director. While the department is sad to see Ms. Lally go, we know she will do great things at the Medical Board, and we wish her the best in her new position. Additionally, the department is welcoming a new Chief Deputy Director, Chris Schultz, and a new Deputy Director of Administration, Natalie Daniel. Before coming to DCA, Mr. Schultz has been a Deputy Commissioner of Community Programs and Policy Initiatives at the California Department of Insurance since 2011, and Mr. Schultz started this Monday. Ms. Daniel has been a Fiscal Supervisor at the Judicial Council of California since 2015 and will be starting with the department on November 7th. She will be overseeing the department's Office of Human Resources, Business Services Office, and Fiscal Operations. There's also some exciting changes at the Office of Board and Bureau Services. The department has reallocated resources to increase staffing for Board and Bureau Services. These new resources will expand the services that we are able to provide, including assistance on and across all licensing and enforcement issues, facilitating intergovernment communication, providing board member and executive officers administrative and technical support, and executing the department's strategic plan. With that, I'm excited to report that 2 new Assistant Deputy Directors will be joining my team under the Office of Board and Bureau Services, Karen Nelson and Patrick Lee. Ms. Nelson has been the Chief Operations Officer at the American Leadership Forum Mountain Valley Chapter since 2014, and Mr. Lee has been Assistant Chief of External Affairs at Covered California since 2015. The department is confident that these staff additions will strengthen our ability to pursue the department's mission and the services we provide to our various boards and bureaus. With that, I'd like to provide you with a couple more updates. In September, the department held the second Directors Quarterly Meeting with board executive officers. These quarterly meetings are an opportunity to ensure the department continues an open dialogue with its boards and bureaus. To that end, we will still be holding an annual meeting with all board presidents to ensure Director Garfilo is available to you and that he can hear feedback from board leadership on the important issues facing the department and its boards and bureaus. That annual meeting is yet to be scheduled. On the new DCA online search, one of the important items that was announced at that meeting that I would like to share with you is that DCA released a new online verification search tool for all boards and bureaus using the Breeze platform. The licensure will expand current functionality and allow the public to conduct more flexible inquiries. For example, the new search allows inline filtering on a range of relevant key data points, including primary and secondary status, city, county, and license type. A key focus when designing the new online license verification search was to ensure better performance, flow, and ease of use for consumers. This new DCA search brings our offering closer to the familiar search capabilities common across the internet, allowing our stakeholders to access the data they require at their fingertips. The department also officially launched its new Future Leadership Development Program in May 2017 and held a kickoff meeting with program participants and mentors in August 2017. The last meeting of the Future Leadership Development participants was this past Tuesday, October 24th, with Senator Jerry Hill. Expanding upon the department's current Leadership Academy training, the department is looking to help develop the best and brightest among the department and its boards and bureaus into its future leaders. The program includes executive mentoring, customized leadership training, and project management. A quick note on Pro Rata. The department has established a Pro Rata work group of DCA and board executives to discuss potential improvements and how DCA communicates with boards on this issue. Pro Rata, as you know, is the process by which the department distributes the costs amongst its boards and bureaus to cover all departmental services such as information technology, legal, and publication services. The work group held its first meeting in August 2017, and its second meeting this past Tuesday. We'll also be hosting a Pro Rata open house, and that's going to be taking place on November 14th. A couple more quick notes here. In July, the department released its new strategic plan. Like the board strategic plan, the department's executive team developed it with the assistance of Solid, and it outlines DCA's goals and objectives for the next 4 years. The plan is available on the publications page of the DCA website. Required board member trainings. The final board member orientation training in 2017 is scheduled for November 15th. There is still room in this class if you need to register. Board members are required to complete this training within 1 year of appointment and reappointment to a board. This is a one-day training in Sacramento which details the important functions and responsibilities of board members. Please contact DCA's Solid team or my Office of Board and Bureau Services if you are interested in attending, or board members can register online. And finally, a reminder that 2017 is a mandatory sexual harassment and prevention training year for the Department of Consumer Affairs. This means that all employees and board members are required to complete this training in 2017, even if it was completed last year. This training is online, interactive, and can be completed at your convenience. If you have questions on this or any of the other required trainings during your tenure as a board member, please do not hesitate to contact my Office of Board and Bureau Services for assistance. I would like to make sure you all know the department is committed to serving its boards and bureaus. Much of the consumer protection value through the department comes from its boards, such as the Optometry Board. We always protect consumers better when we are working strongly together. As always, if the department can be of assistance to your board, please don't hesitate to let me know. Thank you for your diligent work and valued partnership.
Thank you. Any questions or comments of DCA? Mr. Morinaro may make it short.
Very short. I make this speech every time someone new from DCA comes. Thank you. At first, thank you for coming down to Ontario to meet with us.
Thanks for having me.
In our relationship with DCA, it's really important that DCA be straight with us, particularly in the area of legislation. I understand legislation happens very quickly, and there are very many players involved. But there have been occasions in the past when the DCA has not been straight with the board members. And I would like your commitment that you will be straight with us on matters such as legislation, in terms of what the plan is, what the interests are, and where things are going.
Yeah, absolutely. As I mentioned, Jessica, one of my priorities, especially with the expanded Office of Board and Bureau of Services, to maintain very open, efficient, and effective lines of communication. Our office works very closely with our legal and reg team, as you all know, so I certainly don't see any issue with being able to do that.
Thank you. Any other comments? Thank you very much.
Thank you very much.
Future agenda items?
Let me see, I've got a long.
A long list. That's it. And Donna, thank you again for everything. And we're adjourning, but we're going to join you in Batley. We'll be part there for you too.
Thank you.
Thank you all.